Welcome to Jurors in Disguise, the podcast that exposes liars. My name is MaryRose Peterson, and I own Covert Ops Jury Investigations. What do we do? I'm glad you asked. We find the jurors who lied during jury selection so that they would be selected for the jury and deny our clients a fair trial. In a previous podcast, I exposed the lies and schemes and corruption by the criminal mastermind that framed an innocent person. That innocent person is my husband, Martin Peterson. Tonight's podcast, we're going to continue the theme because after Martin was convicted in court in 2012 in Hernando County, he met a man at the jail at county that was also headed to trial. And shortly after Martin's conviction, this man was also convicted in the same courtroom of Judge Daniel B. Merritt Jr., Hernando County, and with the same prosecutor as ours, who is now Judge Erin Daly. At the time, she was Assistant State Attorney Erin Corcoran Daly. This person's name is Take Chan. Take Chan, and everything I say tonight is public record. So I'm not outing anybody, and I'm going to be careful to not disclose details because it's not important what Take Chan was accused of. Just understand that it was a sexual accusation, just like in Martin's case. I made friends with Take Chan's sister shortly after both of the men were sent to prison, and we've stayed in contact all these years. His family has adamantly protested his innocence from day one. And it turns out 2 years after the trial, his stepdaughter accuser also recanted. And again, not going to name names, but they had a hearing about it. A motion was written and they had a hearing in 2014. And I just wanted to read a little piece of this hearing that lasted for several hours. This is not the accuser. This is actually the accuser's mother, who was married to Take Chan at the time. She said, "I didn't know what to believe when she said she lied about Take Chan at first because I wasn't sure, because I know she has a tendency, but when she kept it up for so long, this has been such a long time, and she's never changed it. She's never changed. She has a bad manipulation habit, but from when she first told, she didn't really tell me. She told the counselor, but I was there. I was shocked when she said it, but for a while, I wasn't sure if this was true about him or not, if it was true or not. Still in my mind, I'm like, I don't know. Maybe he did, maybe he didn't. It was really bad. But as time went on for so long, and she kept it up and she kept it up, she even told me I wasn't there. She told the counselors at Baycare I got her Baker acted so many times because she had bipolar disorder and behavioral issues. Her mother said when she got Baker acted, she talked to the counselor, and when they come back and told me that she feels really guilty for lying on my husband, I wasn't even there, and she said I had to call the cops on her a few times, but she stayed with her story. She was adamant about the fact that this never happened. Later during the testimony at the same hearing, the accuser's mom said that she's been consistent, that he didn't do it. Consistent all the way through, because even when she's Baker acted and I'm not there, the counselor came out and said she feels so guilty for lying on Take Chan. She feels so guilty. And she just continued to say that it didn't happen. Shortly after that, they had another hearing, and this time one of the counselors for the Children's Home Society of Florida testified. She was a dependency case manager there. And during her testimony, she said that the accuser told her that she lied about her dad and he didn't do it. She said that when they told her mother, her mother's reaction was very powerful. She said she turned white as a ghost. She started shaking. Well, you could just see her physically shaking, and it was very emotional for her. She stepped aside and she spoke with her daughter for a little while. She got very upset. She was crying about why she lied and why she did this to her dad. It says she was very, very scared that she was going to go to jail. She didn't want to go to jail. She said that many times. She said she was also worried and didn't want her entire family to hate her. She just didn't know what to do, and they were going to hate her, she was sure. She was crying while she was thinking and talking about it. I told her that no matter what, telling the truth is the best thing to do, excuse me, and that she needs to continue to tell the truth. And her family would love her no matter what. I'm just struck by the fact that a child could make a horrible mistake and cause this level of a reaction, and then later come back, grow up a little bit, feel terrible about what they did, and want to absolve themselves, want to be truthful, and they just want to fix things. They go into court and they beg for forgiveness. His daughter took the stand. She cried. I'm told, I was not there. I'm told that she was sobbing to the point of being inconsolable. She felt that she destroyed her family with her lies. She put her stepfather, who she considered dad, in prison for life. And she's trying to explain to people that it wasn't true. And they don't believe her. And do you know, after all of that, denied, said no, didn't believe her. So 4 years goes by. Tate Chan is still in prison. Martin gets out. And theirs was one of the first cases that we started working on because I knew that we had to do something. We had to help this family. They had done everything they know and spent a lot of money on attorneys and gone back to court only to be denied and told, you know what, your recant, I don't believe you. Well, I'm sorry, but a recant should be allowed to be a recant. You should be allowed to recant something that you know is false. But Judge Merritt said no. So we started working on Tate Chan's juror investigation. And it wasn't long before we found one of the jurors had not been at all truthful during the voir dire. I want to read to you, though, some of the things that Judge Merritt said during this voir dire of Tate Chan's. This was in 2012. He began at the beginning of jury selection. Judge Merritt said to the jurors, "Ladies and gentlemen, again, I wish to welcome you to the Hernando County Courthouse. Thank you for responding to your jury summons and make it known to you that you are essential co-workers in the American legal system. The jury is an institution of the old common law and is recognized and protected and preserved in our Constitution. By being called to jury service, you are elevated to the highest pinnacle of civic service in our system of justice, and you are charged with the responsibility of sitting in judgment on the facts and legal controversies involving the lives and properties of your fellow citizens. It is one of the most important duties any citizen can be called upon to perform. For the record, the prospective jury pool has also been given the oath of voir dire, and I have found that they have all met the general requisite qualifications. At this point, it would be appropriate to give you an explanation of what we call the voir dire process. This is the part of the case where the parties and their lawyers have the opportunity to get to know you and a little about you in order to help them come to their own conclusions about your ability to be fair and impartial, so they can decide who they think the jurors should be in this case." And see, I'm going to pause there because this is my pet peeve with jury selections, jury voir dires. Most of the time, and I've read thousands, most of the time, the questions, the way that the jurors are approached, the prospective jurors, it makes it sound like it's their decision whether or not they want to be on the jury. And that's not what it's supposed to be. It's supposed to be an interview for a job, the job of juror. So I do appreciate that about Judge Merritt, that he understood and made it clear that this was the attorney's and Tate Chan's decision as to who would be the jurors in his case. Judge Merritt continued, "How we go about that is as follows. First, I ask some general questions of each of you. Then each of the lawyers will have some specific questions that they will ask you. After they've asked all their questions, I will meet with them and they will tell me their choices for jurors. Each side can ask that I exclude a person from serving on the jury if they can give me a reason to believe that he or she might be unable to be fair and impartial. That is what we call a challenge for cause. The authorities authorities. The attorneys also have a certain number of what are called preemptory challenges, by which they may exclude a person from the jury without giving a reason. By this process of elimination, the remaining persons are selected as the jury. It may take more than one conference among the parties, their attorneys, and myself before the final selections are made. That's really good information, isn't it? That is probably the best, or that is the best explanation of the voir dire process that I've read so far. Good going, Judge Merritt. Then he said the questions the questions you will be asked during this process are not intended to embarrass you or unnecessarily pry into your personal affairs, but it is important that the parties and their attorneys know enough about you to make this important decision. If a question is asked, and I know I'm going on and on about it, and this will be important in a few minutes. It's important to set this up so you understand as a prospective juror in Take Chan's case what was being said to them and what their mindset would have been and what they would be processing before they ever started answering questions. Judge Merritt continued, if a question is asked of you that is a personal issue and that you would prefer not to answer in front of the whole courtroom, just let me know and you can come up here and give your answer just in front of myself and the attorneys. If you have a question of either the attorneys or myself, do not hesitate to let me know. There are no right or wrong answers to the questions that will be asked of you, and I highlighted this in my report. The only thing that I ask is that you answer them as honestly and as frankly and as completely as you can. You have taken an oath to answer all questions truthfully and completely, and you must do so. Remaining silent when you have information you should disclose is a violation of that oath as well. If a juror violates this oath, it may not only result in having to try the case all over again, but also can result in penalty against a juror personally. So again, it is very important that you be as honest and complete with your answers as you possibly can. If you don't understand the question, please raise your hand and ask for an explanation or clarification. In sum, this is a process to assist the parties and their attorneys to select a fair and impartial jury. All of the questions they ask of you are for this purpose. If for any reason you do not think you can be a fair and impartial juror, you must tell us. Then the next question he asked the prospective jurors were, do any of you have any close friends or family that are involved in any aspect of law enforcement? One juror spoke up and said, my ex-brother-in-law is a Pasco County sheriff. Another juror said, cousin, corporal with Hillsborough County. The prospective juror who was later chosen for the jury and who we found was guilty of misconduct said nothing. Another question that Judge Merritt asked, which was key to this case, and in every case really, he said, would any of you place any added trustworthiness to the testimony of that of a uniformed law enforcement officer in contrast to that of any other witness? He paused, then said, see none for the record. Okay, those were the important pieces of the voir dire. Now, what did we find? I'm glad you asked. In searching through the jurors' Facebook page, it took a little while because there were a lot of photos, but we were able to find this. Now, keep in mind, when asked about law enforcement, she said nothing. This was actually posted 4 years after Take Chan's trial. Now, normally that wouldn't matter because it's after trial. You can't prove misconduct. You can't prove bias just by looking at something that happened after trial. And most of the time that is true. However, there are exceptions to that rule. For example, there have been cases where we have found that a juror filed an injunction for an order of protection against domestic violence against a then husband or boyfriend, and it was filed after trial of our client, but it reflected back in time. For example, it would say we were married in 2010 and say the trial, like Take Chan's, was 2012. And the juror might have said something like, "This has been going on from day one. We have I have been beat and abused from the very first day we were married." Things like that. Now you can prove that at the time of voir dire, if they did not answer truthfully to that particular type of question, now you have an injunction with their own handwriting that shows that that was not truthful and they lied and they should not have been on that jury. So when I first saw the picture, I didn't think much of it, except I saw the uniform and the badge, and I thought, huh, that's interesting, because she didn't say anything about law enforcement. But then I thought, oh, it's 4 years after trial. Then I read the caption. This juror wrote, "It's been 8 years." And that would make this 2008. So that was 4 years before Take Chance trial. "It's been 8 years since you were called to meet the maker. There is not," capital letters, there is not one day that goes by where I don't think of you. God bless you, Tony. Gone, but not forgotten." End of watch, July 22nd, 2008. So the next step in our investigation was to figure out who this was that the juror was talking about. We knew that he had been in law enforcement. We knew his name was Tony. We knew that somehow the juror knew him and he was important in her life. And we also knew that his date of death, when he had died. So we began to look into this, and what we were able to find is that the juror's maiden name was Forgione. So then we were able to find that she had a cousin named Anthony Tony Forgione, who had died in the line of duty in 2008. We found this memorial. It says Deputy Anthony Forgione had been with the Okaloosa Sheriff's Department for almost 3 years. Before coming to the Sheriff's Department, he had worked with the Fort Walton Police Department. Working with the special response team, they went into a home after an hour standoff with a mentally ill man that they were trying to help, and they had no response from. Tony died doing what he loved and was trained to do. He leaves behind his wife and 2 young daughters. In life, Deputy Forgione walked that thin blue line to serve and protect the community he loved, and left this life doing just that. He leaves a brother who also works for a local police department, so through him, his work will carry on. Then this was interesting. It said his death marks the first death that the Okaloosa County Sheriff's Department has had since 1921. So the juror's cousin was killed in the line of duty. It's horrible. It's tragic. And I can understand why not a day would go by where she wouldn't mourn his passing and thinking of him. This gave us an additional piece of information. So now we knew that this juror had 2 cousins who were in law enforcement. Now, granted that Tony had been passed away before Tate Chan's trial, but there was another cousin out there who was still in the line of duty according to that. So then we started looking into more of this, and we found that the death of Tony Forgione, Deputy Forgione, left quite a mark on the Okaloosa County community, and rightly so. And this is, of course, a Florida case. So this was in the panhandle of Florida, and there was even a canine that was named after him. He was named Canine Forge, and he became one of the police dogs named in Tony's honor, which I thought was really cool. I'm a dog lover, so I would think that was cool. We found a Facebook post where they had named a bridge after him. That's his mother there, pointing to the sign. The sign says Deputies Tony Forgione and Bill Myers Memorial Bridge. And on the post, the juror wrote, "How beautiful." So now we know she knew. Then we were looking into the cousin and found that he had started a nonprofit organization right before Tate Chan's trial called the Northwest Florida Chapter of Concerns of Police Survivors, Inc. And this is the logo. Cops. This is going to be important later on, well, in a few minutes. So the juror's cousin, who was surviving, formed this organization in honor of his brother. There was also a Facebook page with that cops organization put together, and on there it says the 3rd annual Anthony Forgione SWAT competition. So we found that every year they had a SWAT team competition in his honor. So a lot of memorials of this juror's cousin. So based on all of that, Brian Savy, who you've met in a previous podcast, was hired to write the motion for a new trial, juror interview, disclosing all of the evidence that we found that this juror had not been truthful. In the motion that Attorney Savy wrote, he stated, the juror's first cousin, Anthony Tony Forgione, was an Okaloosa County Sheriff's deputy who was killed in the line of duty on July 22, 2008 by an escaped mental health patient. This occurred less than 4 years prior to the defendant's trial. Deputy Forgiones was the first officer ever killed in the line of duty in Okaloosa County. The Florida Senate passed legislation to reform the state's Baker Act in his honor. The residents of the Okaloosa County continue to hold annual memorials. They even named a bridge after him, as I said. And the sign is posted on the juror's Facebook page with the comment, "How beautiful." At the time this juror appeared for a juror in defendant's trial, she was aware of her law enforcement officer cousin's murder, as evidenced by a tribute she posted. It's been 8 years since you were called to meet the Maker. There is not one day that goes by where I don't think of you, gone but not forgotten. Furthermore, Deputy Tony Forgione's brother, Joseph Joey Forgione, is a deputy with the Niceville Police Department. He was an active law enforcement officer at the time of the defendant's trial, and it appears he is still a police officer. At the time of my writing the report, we had been unable to determine where he was still working, but it did appear that he was still with the police department. During voir dire, this juror intentionally concealed information about having family members, specifically her cousins, that worked in law enforcement. The information discovered about her could not have been easily discovered by the complaining party, and it was not due to any lack of due diligence. The photo of Deputy Anthony Forgione on the juror's Facebook page was not posted until 4 years after Tate Chan's trial. She also presented herself at trial as a single woman. So we thought we were under the impression, because when Judge Merritt asked her if she was married, she said no. We thought then that her last name at the time of trial was her maiden name. Turns out that was a married name, and she was still married to someone at that time. That's what took a little time to find, that her maiden name was Forgione. So the last 2 pages of Attorney Savy's report, motion, said during voir dire, this juror concealed the fact that she had 2 family members, her cousins, who worked in law enforcement. One of her cousins was an active law enforcement officer at the time of the defendant's trial, or so we thought at the time. Jurors were asked specifically about any family members involved in any aspect of law enforcement. Any aspect. 3 other prospective jurors divulged that they had family members who worked in law enforcement. One even said she had a cousin, just like the jurors, and she said nothing. This juror concealed information on a critical topic that was relevant and material to her jury service in the case, and that's the important part about Florida. We have to prove that the concealment was material to the case and that it was concealed. It was intentional. There was bias there. That's why. I know I mentioned before, Attorney Michael Efferman says something to the fact that you lied, therefore you were biased. That should be the standard, and that pretty much is the standard, but the courts are not abiding by that, as you'll see. But Attorney Savy said, in the instant case, law enforcement exercised discretion to arrest and charge defendant without any physical evidence, which means that law enforcement determined the word of the stepdaughter, who was 12 at the time, I might say, who has also since recanted her abuse allegations against the defendant, and another woman who had previously recanted her abuse allegations against the defendant. So the law enforcement officers felt like they were credible enough to proceed. Furthermore, law enforcement officers testified against Tate Chan and Furthermore, law enforcement officers testified against the defendant, Take Cham, and recited statements that this girl, his stepdaughter accuser, had allegedly made to them and essentially helped her tell her version of the events to the jury. Thus, the credibility of the police was paramount to the state's case against the defendant, which only exacerbated the effect of Juror Pigeon's intentional and material concealment. That was the motion that Attorney Saby wrote. Felt like it was beautifully done, as are all of the things that he writes. This is the state's response, written by then Assistant State Attorney Aaron Corcoran Daly. I'm not going to read all of it, but I wanted to read a little bit of it. She said, "The state is not aware of any close friends or family members of this juror who were actively involved in law enforcement at the time, as the verb tense of the question indicates. Are, A-R-E." So she's arguing over the word are, which is pretty typical. I was told by an attorney when I was working on Martin's case that he learned in law school the state will argue over a period and they will indict a ham sandwich. And I think that this is, from based on my experience, that is an accurate statement. But according to Aaron Daly, this juror was truthful in remaining silent. Well, I'm going to have to agree to disagree with you on that one, Ms. Daly. This is the other thing. I've said this before, but I'm going to say it again. It bears repeating, as I say. One of the shocking aspects of what I do for a living, is the reaction of the judges and the state attorneys across the board. When we come back into court and we show them, hey, this person wasn't truthful and they lied their way onto that jury, and we don't know what kind of difference that it makes or made, but this jury is tainted. The verdict is out. It's no good. My shock has been that instead of the juror being the common enemy because the juror mucked up the trial, and now what are we going to do? No. These people, the state, they're angry at me. They are writing scathing things about me, and even in this one with Ms. Daly. And I don't understand, why are you so defensive? You should be angry at the juror for coming in and lying to your face and denying this person a fair trial, because Judge Mary, you just said that all of this was to create and choose, or create an environment of fairness and to choose an impartial jury. And so when we came back into your courtroom and we showed you that that didn't happen, I don't understand. You're supposed to be impartial. You're supposed to be unbiased. You're supposed to call balls and strikes, as judges say. This struck me as not only unprofessional, but this part of Miss Daly's response. So now she's not only attacking me, now she's going after Attorney Savy. She said, had Mr. Savy done any actual and appropriate research into the easily verifiable employment information of the cousin of the juror, the court's time would not be wasted on this frivolous motion based purely on defendant's attorney's speculations. So hundreds and hundreds of hours of work that we put into this, along with Attorney Savy, yeah, we're just speculating. We're wasting the court's time. Not only was it clear that Ms. Daly was pissed and willing to use verbiage that was not only unprofessional but slanderous in her response, she actually called the juror's now ex-husband in New Hampshire and asked him if he considered himself married to the juror at the time of trial, because the juror was asked if she was married and she said no. And he said no, we'd been separated and did not consider ourselves married. Well, that's the problem, though. That wasn't the question. The question was, are you married? Now, if you're not married, you say no, which is what she said. If you're married but you're separated, then the appropriate reaction and response would be, we're separated, or I'm divorced, if that's the case. And again, that's an insight into your, as a female, ability to get along with males. If you were separated, was there something that your then husband did to cause you to have a bias against men in general? Are you going to bring that into Take Chan's trial and into his jury deliberation room? Inquiring minds needed to know that. So that's why that answer to that question that was false was so important. But Ms. Daly went to great lengths to prove us wrong. Then she said in the conclusion, the defendant, now keep in mind that this is many years after trial, and everyone is aware of the fact that his daughter accuser had recanted. Yet, in Ms. Daly's response in the conclusion, she said the defendant was properly tried, properly convicted, and properly sentenced. We live in a civilized society which holds individuals accountable for their actions. Then she says there's a chief judge that eloquently quoted in his dissenting opinion, quote, "If you can't do the time, then don't do the crime." Those words are going to resonate with you, Ms. Daly, because they apply to you as well. That was what she wrote. Then, as Exhibit A, she included, and this is where it gets interesting. You may recall from the last several podcasts, I talk about all the transcripts that were altered and the testimony that was switched up and the notes that were switched and altered, all by Ms. Daly in order to frame an innocent man. So on this email feed that she attached as Exhibit A, it's an email between her and the juror's living cousin, who had apparently been exchanging emails, and it sounds like she even called and spoke to him at one point, but I can't be sure of that. He said, "Good afternoon, Aaron. Hope you don't mind, but cleaned it up some." Cleaned what up? What needed to be cleaned up? And then he goes on to list basically his resume. And then in Exhibit B, Ms. Daly submitted an email from email feed of her and a Captain Michael Whitfield with the Niceville Police Department. And in this, Captain Whitfield said, this Joey Forgione began with us as an auxiliary officer, and he puts the dates. He then went full-time as an officer and puts the dates. Joey then transferred to the Okaloosa County Sheriff's Department as a deputy and puts the dates. He returned to us as an officer on these dates. He went part-time as an officer with Crestview Police Department on 10/08/2013 to 08/20/2014. Hope this helps. Now, at the time, I didn't think much of it. But in preparing for this podcast, I went back and went, wait a minute. Wait. Just a minute here. First thing I noticed was that on the email, Captain Michael J. Whitfield signed it, that automatic thing that when you send an email, you have it set up where it's automatically puts your information. But the problem with that is that the city of Niceville is missing an E on the end. Niceville Police Department with no E on the end of it. I thought that was interesting, especially given this is a captain. And then I took the, this is going to look eerily familiar to you. So I took the email from the juror's cousin and I compared it to the email from this captain from the Niceville Police Department. They are word for word exactly the same. Word for word. What does that sound like? If you watch the other podcast, you know what that sounds like. Word for word, really. I find that hard to believe. So, Did Ms. Daly, is this truthful or was it fabricated? Thank you for watching. If you know of someone who has been convicted and needs our help, you will find our contact information in the description below. Be sure to like and subscribe. It means a lot that you follow us. I'm very grateful. Thank you again for taking time. And as we like to say, the courtrooms may be silent, but we won't be. So speak up, speak out, and always speak the truth.